Doyen of the Indian judiciary, and perhaps in times when we see degradation in standards of public life, respected Honorable Justice Santosh Hegde, I was about to say that he stands out as a beacon in times when we are seeing degradation of values in all walks of life. Keeping up to that high standards is one of the biggest challenges of life, and he is a role model to us. Likewise, Justice Ramchandran, former judge of the Kerala High Court, who is here amidst us, and Beena Pillai, who is instrumental in bringing us all together. It is very difficult to bring persons with some sort of a legal interest, some sort of an interest in such a subject as apartment law. To bring them together is a big challenge, and I thank her for that. In the same way, Mr. Rafiq Moinuddin is also here. I thank him for his presence. Mr. Vinay, the Apartment Federation. I think Mr. Vinay is an important person here because from the 20 years of boom that we have seen in Bangalore, this is perhaps the fastest growing city in the world, and definitely the fastest growing city in Asia. And to be the link for all the apartment owners is a huge responsibility. I thank the other guests on the podium, and I'll begin my lecture. I'll be short. One thing is, this is a very interesting area. What generally is apartment law? If you were to ask me, I would say, from the time you set out to buy an apartment till the time it is delivered to you, and after delivery begins another big story, the post-delivery story, for which today we have a lot of legal grey areas and which requires illumination and understanding. And where apartment owners have clear knowledge about these specificities after the purchase of the property, I think it will make a better and a safer journey or a more happier way to live in the apartments that where we reside, if at all we have that clarity. First of all, regarding title, Bangalore has proliferated, as I said, since the past 2 decades. And it has expanded so much. You have municipal areas and you have rural areas. Now, over all these areas, you go to buy an apartment, there are numerous builders. You have a huge catalogue of builders. We tend to rate them as grade A, grade B, grade C builders, but in any case, after coming of RERA, all of them have been brought into a single standard. And that is a very good transformative legislation which applies to the whole of India. So therefore, when you look at these, when you go to purchase an apartment, you generally tend to go to a lawyer. He will guide you on title issues. In and around Bangalore, there are certain unique problems. One of the biggest challenges here is how do you get clear title? So you have to be wary. I'll just give you a broad sketch. You have to look into family law, succession law, because most of the properties are Hindu law oriented properties. Therefore, you have succession. If it is an ancestral property, there is a line of succession. Everybody has to have participated in conveying the title or in coming it together for the joint development. If it is an individual ownership property, then you have to ensure that every person who has right has participated. Only then will you have a transference, clear transference of title. So therefore, when you go, this domain is huge. There are a number of lawyers who are very good on the conveyancing side. In fact, there are hundreds and hundreds of lawyers throughout the city who specialize in conveyancing. So my advice is, go to a lawyer who does conveyancing and who has a good track record, and find out the specificities of the property and the clearance of title. Now, another misconception is that if it is RERA approved, the title is clear. No. RERA just gives you the sanction plans. It is a sanctioning authority and ensures compliance post-sanction and ensures adherence of timelines. But RERA does not give you a guarantee on title. Therefore, you will have to make your individual investigations on title and ensure that it is clear and it is a transparent title. A very important issue that came up to me was, there was a big builder. They asked me a legal suggestion. They asked me, sir, we have a civic amenity area and this is about 1 acre in a huge development. In this civic amenity area, we have a clubhouse. Now the residents there want to build a few apartments above the clubhouse and they want to sell this. Is it possible to sell? What is your opinion? Then I told them immediately, look here, you have the Vidhan Saudha here. Somebody says, I'll tell you that I'll sell the Vidhan Saudha to you. Can you sell it? Civic amenity areas are public domain areas. They are devoted to public causes. They are devoted to the community. So therefore, please do not encourage any, because we all reside in villas, we reside in apartments. Somebody comes up with this wild idea that we'll do a development on the civic community. No. It is dedicated in trust to the association. The concept of trust exists there. And once it is a trust, then you have to use it for that public purpose. You cannot use it for any other purpose. So there is some clarity, there has to be some clarity on that. After you purchase, then today luckily we have RERA. Otherwise, the law in this area was void. What is the date on which you should have given the delivery? What are the stages at which the construction must go on? There was nothing, there was no framework of law to hold the builder liable. And as purchasers, we are interested in ensuring that this framework is there. So RERA gives this deadline, the timelines. And they have to adhere to these timelines. You can file complaints before the RERA authority and it adjudicates. There is adjudicating authority also. The last issue is, you succeed in getting a good property with title. Now in Bangalore, again, this comes with a caveat and a condition. There is so much of litigation in Bangalore because values have expanded so high. So you should be very careful that the property you purchase does not have a litigation. This is a very important thing. So how do you undertake this exercise? You should ensure that the builder has given a paper publication over this property through his lawyer. And you should ensure that you make an independent scrutiny of the documents. I once had a case, personally, because we engage in litigation, I once had a case where about 60 apartments were purchased by flat owners throughout India. You know, Bangalore is such a wonderful and a cosmopolitan city. You have people from Jammu, Kashmir to Kanyakumari, from Mizoram to Kutch, Gujarat, who are all there in one single apartment. This is the diversity which Bangalore represents. And unfortunately, the earlier owner got an eviction order. All the 60 of them were evicted overnight. And they came to the court. We tried to safeguard them through an injunction, but by then they were evicted. Then we finally settled the matter, and on the day of settlement, I was astonished, sir. All the 60 families had come because they had to give their signatures, they had to sign the papers to the court. So the judge asked me, Mr. Reddy was a district court judge, asked me, Mr. Reddy, I find in the Aadhaar cards given by them and their identity cards, you find the whole of India here. in a development by a C grade developer, not even an A grade developer. So such is the demand, such is the responsibility, and you must ensure that the titles and your legal papers are perfect. Then we come to post purchase. Now that is where the real pain area begins. Everybody will have a problem with the developer because material defects are there, common civic amenity usage charges are there. Now what has happened? Earlier, the law as it existed, in 1972 there was a Karnataka Apartment Owners Act. All of you would have read that act because everybody who has come here, I think, is sort of aware of the legal landscape. Now this act is an archaic act of very old times. Nevertheless, the act makes it incumbent to establish an association and hand over with a deed of declaration. Now, there were many defects in this act. The RERA has also interfered in this position by a central enactment. And the RERA says that within a time frame, the owner must hand over the civic amenities to the association. And it also says that it also gives freedom to the local law. Therefore, the RERA has allowed 1972 Act also to have some play. But it says that you must have an association formed. Now, always I find, I don't know whether what I am saying is resonates with you, I find that builders try to control the post-sale management of the civic amenity. And that's where there is the friction. The builders say, no, I have an agency, the agency will manage, you pay this much per square feet. And this is questioned by at least 50% of the residents who are unhappy with this situation. They say the charges are too high. So what should be the actual charges? When an association is formed, the association has an independent mechanism to adjudicate the charges and divide it amongst everybody. But of course, association also get riled into politics, and there is, within a few days, within the apartment owners association, I find that there is scuffle between two parties. This is all there, this is all part of democracy, but still, I think the time has come that builders acknowledge the responsibility to hand over, and a responsible association takes over. Charges are commensurately shared between everybody. I think such a time has come where there must be a transparent process to ensure that this is done. Though RERA does not give that ending story, the ending journey of a buyer's journey in getting an apartment, RERA has kept a large gaping hole regarding that end situation. I think there must be suitable amendment in that enactment to ensure that this is safely negotiated and there should be no squabbles over this. If there is clarity in law, you have less of squabbles, less of litigation. If there is no clarity in law, then we lawyers come into play. You all have to come to us. This is the situation. Therefore, and there is one debated question. I will put it to Justice Santosh Hegde sir and Sri Ramachandran sir. A hotly debated question. After formation, why should you form an association? Let's form a cooperative society. And let the cooperative society format govern the charges. There is some misconception here. What is a cooperative society? A cooperative society or a cooperative federation is a place where you own shares. Suppose there is a milk union. You see milk unions which started from Gujarat and Maharashtra. The same concept has spread over the entire nation. That is a cooperative federation of milk unions where everybody has a share and everybody participates in that milk business. Some are suppliers of milk, others are processors of milk, others are end users of milk. Now this is for an apartment. What sort of a cooperative federation format can you give? What sort of a shape of a cooperative federation format can you give? In Bombay, where this practice is prevalent, a person owns shares and thereby it is equated that he owns a property. The same format applies in Companies Act also. where a person owns shares in a building. It's a building is a venture. He owns shares, therefore he owns an apartment or he owns an office space. In Bangalore, I find that over it's the long history of property law in Bangalore, I find that people are more happy having a deed which they have. Let us say a sale deed over a property is the safest way of holding a property than holding a share. Otherwise, we sort of get into a Chinese problem. Because the other day we had a Law Asia conference. So there were lawyers from China. I invited them to our Advocates Association. Behind the stage, because you can't ask the Chinese to speak openly, behind the stage I asked them, sir, can you hold property in China? They said, there is no concept of holding property in China. Then how do your children, at least I want to give my property to my children, that's some happiness in life, or I want to hold property in my life, that is some happiness in life. He said, his name was Mr. Chang, he was a leading lawyer. He said, Mr. Reddy, if I buy a property, it's for a tenure. I buy it for 50 years, long tenure. It may go beyond my lifetime. But it ends after that. It goes back to the government. So, kindly compare these systems of these are two huge countries, India and China, world's biggest countries. Our ancient law, along with modern law, permits the holding of property. And it is a very important aspect of freedom, which we enjoy in this nation. If someone were to say, all right, throughout your life you earn, but you cannot hold property, what sort of freedom is that? So it goes into these questions. But my point is, why get into a cooperative format where you hold shares and therefore vice versa, you hold property? Rather, it is better to have a deed for yourself. The deed guarantees you the right to that property, and the deed is conveyable. You can liquidate that anytime. If you want money, you can sell it and then take the money, invest it elsewhere. So this is the sort of security that we must have. Therefore, if anybody says, look here, after purchasing the deed, after taking possession, I am going to form a cooperative society. For what purpose? Only for handling the amenities? Then an association is the fit system. There is a framework of law. Just take over this through an association. Another indication towards this is the RERA Act. The RERA Act says, after completing the project and handing over possession, you give it to the association. It does not say give it to a cooperative society. So therefore, friends, keeping all these aspects in mind, of course, further discussions will open many more questions. The areas where I have tried to bring out is the transference of title and litigation-free properties purchase, the deadlines within which it has to be taken, and that you have rights if those deadlines are not adhered to, and lastly, a safely negotiated journey towards civic amenity maintenance, where it should be shared commensurately between everybody, and you should not end up in a situation where the builder makes exorbitant profits. So keeping all this in mind, I think this apartment law is this issue or this subject is the subject for the next 2 or 3 decades in Bangalore city, because there is so much of area which is yet to be developed and the infrastructure in the city is bursting. Another question that we as citizens must ask is the infrastructure of the BBMP really coping up with the influx of population and development of the city? I think there is serious deficiency. We are growing in exponential proportions, but we do not find a commensurate and proportional interference by the civic bodies or organizational readiness of the civic bodies to tackle the infrastructural problems of Bangalore city. Therefore, we hope all these issues are addressed, and I thank you very much for giving me an opportunity.
Actually, when faced with an august audience like this, I was really wondering why I have been dragged into this. Maybe the organizers thought that I can speak something about the law. That also, I think I will have to disillusion them or disappointment them. I will share some random thoughts with you. Now, Mr. Reddy has exhaustively dealt with the chief problems of the apartment owners. Now the subject is apartment laws. Karnataka Apartment Ownership Act, it has come into force in 1972. Then I had some cursory reading of the Kerala Parallel Act, which had come into force only in 1984. And I find, rather, I have noted that it is a replica, ditto of the Karnataka Act, except changing some small words here and there. Just a copy. If it was an SSLC or school final examination, definitely that act will not be given any mark because it is a copy of somebody else's act.
So now the problem, First World War and Second World War is over. Now the Third World War is through WhatsApp. I have seen a lot of communications. I don't know for what reason people are fighting in the same apartment. It's a joint family in every apartment. The concept is that it is completely based on joint family system. If you ask me why are you here, I'll tell you one answer. I am the absolute owner of a property. I am an apartment owner. I have a piece of land connected with that. I am not ready to sell or I am not ready to convey to any organization where my property rights where I have. I'll repeat it. I have an apartment. Along with that, I have a piece of land. We call it as undivided share. The difference between this piece of land and an individual house is only one difference. This cannot be divided. That is why we call it as undivided.
When I had a talk with Miss Bina Pillai sometime back, she was emphasizing on the need of such a lecture on the apartment owners' rights and privileges. When she was talking to me on that, her thought was that it could be restricted to either students or to the apartment associations. That moment I thought, why can't it be to the public, to the owners of the apartments who are really affected? We have the guest from the Federation of Apartment Owners Association. The Federation has the collective of all the apartment owners associations. But still, the owners' voices are unheard. The association's voices are heard in the federation. Federation moves it up to the government levels, go to the authorities, does whatever they can do, but the owners are still unanswered.
I am standing before you by representing the Bangalore Apartment Federation. Bangalore Apartment Federation is a largest association of apartments in Bengaluru, having about 1,270 apartments and about 3 lakh residences and 15 lakh citizens are part of this association, this federation. And I thank the organizer for organizing this event and also my due regards to the dignitaries on the stage and elderly person and participants here. When we talk about apartment law, it has a very huge, doesn't restrict only to the apartment law what we talk about management and maintenance of the association. It goes beyond that, which includes in terms of the BESCOM, pollution control boards, electricity, income tax, GST, revenue act,
All those things are also part of your apartment law as a bigger aspects of it. When we think about the apartment, the government responsibilities are now transferred to the committee or a group housing project. It was a responsibility of a government to manage the road, electricity, water treatment or the garbage collection and the processing of it. Now the concept of that is now transferred entirely to the apartment owners. The collective of apartment owners are now engaging the management committee or office bearers, and it's the responsibility of those office bearers to manage and maintain it. When we say this to when we say this to happen, we should have a stronger law which related to the management and maintenance of the apartment. That is what is very important aspect for us to understand about the apartment law. Why apartment law? Okay, so that is a fundamental aspect, and it's a unfortunate that in spite of 50 years of 1972 Apartment Ownership Act was drafted and enacted, there is no competent authority for that to regulate it. Even though government has notified the competent authority as the cooperative society, Register of Cooperative Society, however, Register of Cooperative Societies are accepting the deed of declaration and the Form B on registration of your apartment ownership under Apartment Ownership Act. However, when we contacted them, there is no regulations and there is no specific direction from the government for the going forward. So this is one thing which we should remember. And we all know that RERA has enacted in 2016 and implemented from 2017. Very transformative law for the real estate industry. Even though we call real estate is the second largest next to the agriculture, or probably second largest in terms of the employment or the revenue generation. However, we did not add a regulator to regulate this industry over 7 decades. That's very unfortunate. However, in 2017, this being the central act, and there is a state government to appoint form the authority and also regulate it. So most of the states have implemented, appointed and also engaged the regulatory authorities. Same so for the Karnataka also. Probably the authority is regulating to the best of their abilities. For your information, RERA has itself, this being the industry related regulator, RERA Act has an inbuilt mechanism in terms of the association formation also. Section 11(4)(e) of the RERA Act as make a mandatory for every promoter. Promoter means a builder and developer to enable the formation of an association once the 50% of the units are booked in the project. It is not the formation, we say enable the formation of an association. What do you mean by enabling the formation of an association has to be delved into. Just only calling the members, calling the buyers to come forward to form an association of allottees is the only thing, or he should register himself the association, because RERA is the act for the real estate projects. So when RERA says it's enable the formation of an association, and also it continue to say that society or a cooperative society or a federation as per the local law which is prevails. So for the state of Karnataka, specifically for the management and maintenance of the act, what we have is a Karnataka Apartment Ownership Act 1972. A very specific act for the purpose of management and maintenance of the act. And also the specific objective of the act is very clear, the heritable and transferable of the property by an individual user and the owner of it. So when we have a specific law related to the apartment management and maintenance, I don't think as BAP doesn't look forward to go beyond any other act which is required. Probably this act require a new life to it because it's a 1972, we are 2024. 50 years plus, lot of changes, a large projects have come into picture, lot of changes in terms of the way we manage it and the people who live in the apartment. We have to delve into how we can enlarge it, how we can make it better. And also this is the only act which empowers the committee or the management to create a charge for the dues of the residents or the owners of the act. Consider if you go before, any other act doesn't give the right to charge on the property of the owner for the dues. So these are all the very specific to the management and maintenance of the apartment. So we felt that this act is very apt for the Karnataka Apartment Ownership and Management Act. And also there are various other aspects to it in terms of what should be a good apartment law should have it. See, generally this law is should have many things: how to form it, how to register it, and how to hand over the assets from the promoter, which are the common assets from the builder to the association, apart from the immovable property. As we know that various assets, movable assets as part of the apartment, those how do we hand over? Those things should also be built in as part of the apartment, a good apartment act. And also how do we manage it? Who can be the managers? Who can be the management committee? What could be their qualification? What could be the composition of the committee also? And how to maintain it? How to collect the money? And what could be the composition of the expenses? And whom to report it, whom to report these activities of the association, because we know that many of the association office bearers do not report to the owners or the members of it association. So a good act should bring in these aspects also, and the governance issue of the apartment, responsibility and rights of the management committee as well as the owners of the apartment, and also liabilities. This is a very important aspect. The recent incidents in Karnataka, especially in Bangalore, one of the large project, a death of a girl for whatever be the reason, the management committee's president, vice president and couple of other representatives have arrested, and I think they are bail after 14 days. The reason is the management committee are on voluntary basis. I don't think any of the committee members demand for a remuneration or take a remuneration. They are all on an obligation basis and a voluntary basis. If there is no legal immunity, if there is no legal protection to these office bearers or committee members, it becomes difficult for any of us to represent or be a leader part of it. So we should look at what should be the liabilities and also a legal protection to the office bearers. And also this could be the part of your management and maintenance. What will happen after that also should be looked into. Like in case of a redevelopment of a project, I am sure that Maharashtra has a larger redevelopment of a project. There is a redevelopment act there. In Karnataka we do not have it. For your information, Tamil Nadu has come out with, in case of a redevelopment, what should be the consensus and what should be the confirmation they required for them to go for a redevelopment. So the good law relating to the apartment should also have the concept of redevelopment, and when and how the redevelopment should also happen. The minimum aspects of the redevelopment should be there, and also in terms of any compulsory acquisition of the part or the full project land should also be delved into that. A recent incidents of the, I think Metro has acquired some of the land related to the apartment, and also court has ordered to deposit the money with the court and you continue with your development activity. So how do we take this money, and who will be the owners and who will get the benefit of this money should also be part of the Good Apartment Ownership Act. Presently, many of the good governance, good aspects of the apartment which is developed over the period is missing in the Karnataka Apartment Ownership Act. It's not only with the Karnataka Apartment Ownership Act, most of the act, the good aspects and the practical aspects are missing at this point of time, and we hope and wish that those aspects also would be implemented by the government based on the input or the demand of the public at large. And as you know that most of the states are turning or maybe implementing the Apartment Ownership Act without looking into any other act for the sake, like recent development of Tamil Nadu, West Bengal, Odisha, and also Maharashtra. Anyhow, they have a Maharashtra Apartment Ownership Act which is prevails. even though they have a housing society model, even they also have a Maharashtra Apartment Ownership Act for the other than the society model. The way we have a UDS undivided share in the Karnataka or Bangalore, similarly they have a UDS concept. For them, what governs is the Maharashtra Apartment Ownership Act, but however that is fairly developed and fairly amended from time to time. So, in our opinion, the Bangalore Apartment Federation always feels that Apartment Ownership Act is apt for the management and maintenance of the apartments at all point of time. However, in terms of whatever is missing, whatever we can improvise on that, that should be represented to the government. In this background, BAF has met almost 15 MLAs in the last month before the assembly meeting, where we have given a representative to protect the apartment owners in terms of the management, maintenance, legal immunity, also their properties in a better way. So the same thing has brought in the assembly meeting, raised by Mr. Ravi Subramanya MLA, and also our deputy Chief Minister Sri Shiv Kumar ji has replied that yes, we are aware of it and we would be delving into that, and they say that new act would be implemented, whether it's a new act or existing act can be amended for a better implementation of it. So with this I am concluding my talk, and also a stand of the BAF which related to the management and maintenance of the apartment. Thank you very much.
Good evening to one and all. You must be wondering, having accepted to be the chief guest of this program, how come that I am the last speaker? That's because of my ignorance. I live in an apartment for the last about 15 years, but sincerely, I did not know the laws governing the apartment vis-a-vis the builders and whatever the thing is. I think I am more ignorant than most of the people sitting here. In that context, when I was asked to preside over the function, I didn't even bother to find out what was the subject that is being discussed in the matter. I thought I get many an invitation and I speak about only one thing, the falling social values and its consequences. I thought maybe I could talk about that. Then I realized this meeting is going to be one that is going to be held for discussing the problems of the owners of the flat vis-a-vis the builders and other problems connected with the apartment. I tried to recuse myself from coming to the meeting because I did not want to publicly admit that I don't know anything about the apartment laws, but my request was not accepted. So I said I put one condition that I will be the last speaker, because I could make out somewhat of a case to decide at the end of the meeting. After hearing two lawyers arguing for days together, as a judge I could deliver a judgment. So I thought I would do that. Ladies and gentlemen, I have heard a lot of expression of problems faced by the owners, occupants, builders, and all about the apartment, which I am sure is there in my apartment also, but I never bothered to find out about it now. But the speakers here are placed before this body a lot of things that are happening in the administration and the governing as per the laws that are existing today. And some very good suggestions have also been made. Having listened to this, I do appreciate the contention that there is a need for a much stronger law, which will face all the problems that is being faced by different people involved in the apartment issues. As it said, it could be the builder, it could be the management, it could be the laws that are there, it could be RERA or even the apartment owners enactment. Therefore, there is a need for a comprehensive law, and that law is needed at the earliest, because in my opinion, in Karnataka, if not in all states in India, at least 50% of the metropolis are living in apartment and they have their own problems. I think it's high time the concerned government took care of that. For that, there is a need of a united apartment owners to meet together and develop a draft enactment to place it before the government and ask the government to pass a bill and make a law based on the request that's made by the apartment owners unanimously. It should be that thing. And in my opinion, because of the problems that are faced, which is humongous, I think there is a need for a separate department in the government to deal with the problems of the apartment owners. I'm not saying there should be a ministry. I don't want a minister, but I want a department in the government which will look into the complaints of the apartment owners and deal it in accordance with law. That apart, the disputes that are coming over, I'm told there are some cases which are pending in the High Court in the thing. I would also suggest there should be a separate legal forum for deciding the disputes pertaining to the flat owners. These are certain representations we have to make it to the government. After studying it ourselves and coming into a unanimous conclusion, because there is bound to be difference of opinion amongst ourselves also. Therefore, the representatives of the different apartments and the apartment owners associations and management and other things can sit together before meeting the government officials and have a common representation to the government to be given. And I assure you my full cooperation in that matter and help the party to solve the problem that is there and all. And it's high time we did realize that we should have a separate law, a separate legal forum. There is a separate legal forum for everything now. For the disputes under the Cooperatives Act, there is a separate tribunal is there, and the matter goes before the High Court only as a appeal matter. Similarly, when you go to company disputes go before company tribunal, many other disputes also go, service matters go before a separate tribunal, because in the regular court, if it goes, it takes decades and decades before it could be decided. These are certain general things which I could think of suggesting to this body, and as I said, we could meet sometime, the representatives meet sometime, discuss these various things, there may be some of the things that are impractical, and those things can be kept out, because otherwise that will be taken up by the people concerned and say, okay, this is your representation, we will not deal with it, so that we could arrive some common representation that could be given to the government. This is what I can suggest to you, but I will assure you I have learned a lot about the problems of the apartment owners, and I will be definitely available for you to give any suggestion if need be. Thank you very much for giving me this opportunity.
The question is revolving UDS, UDS and conveyance deed. What do you mean by UDS? Can anybody show me any law book which says the definition of UDS? There is no definition of UDS in the law book. It is called undivided share of interest. It is UDI, which is defined in the law book for property laws. Second, when somebody says you have been given an undivided share of interest of 500 square feet, where will I check I have my names reflecting in the land records? Please understand. When somebody says sale deed mentions the undivided share, that's a contractual obligation as per the Transfer of Property Act, and the property is transferred. What do you mean by property? Property means your flat plus undivided share of interest. Where will I see the undivided share of interest? In Karnataka, unfortunately or fortunately, it's been calculated based on the square feet of the land. Where will I see my name in the land records which says Mr. Dhananjaya or Mr. Anil has got a 600 square feet of land in his name? It doesn't exist. It exists only in somebody's in sale deeds. But sale deed is not the only document. While I am one of the victims where two premier builder, I will not take the names, I think you may be searching, ED investigation will find out. There is one more premier builder who is a public listed company, mortgaged my apartment land for 160 crores and 600 crores after sale deed executed. If High Court is saying that, sale deed itself confirms the transfer of common area, how can any promoter mortgage my land? You need to think these lines. If common area is already transferred in your name, how can a builder or a landowner mortgage my land? This is a fundamental question we have been raising with all the government authorities. Let me tell you, we have registered 100 RERA complaints against more than 30 to 50 builders in Bangalore from Karnataka Home Buyers Forum members. For what? Section 17 of RERA complaints. Section 17 of RERA says title to be transferred to Association of Authorities. We don't care which is the Association of Authorities. Whether you register under KOA, whether you register under COFA, whether you register under whichever is the act you come up with. What we want is RERA Section 17 compliance, which clearly says title to be transferred to Association of Authorities. How can Association of Authorities can get a title? Only if it is a body corporate. Only if it is a body corporate you can transfer the title. That is exactly why these all cases are being registered, and there are a couple of more cases coming up in the High Court. Next week there are 2 important cases coming up in the High Court where it is getting challenged on some of the orders have already been passed in the High Court. So with that note, UDS doesn't reflect your name in land records. Thank you.